Thank you all very much for joining us today for Hunton's webinar to address the new California Consumer Privacy Act. As many of you know, I'm Lisa Soto, and I lead Hunton's global privacy and cybersecurity practice. If you have any questions throughout the program, please use the chat feature on your screen to type your questions, and if we have time at the end of the program, we will address your questions, or we can certainly do so after the webinar. I'd like to introduce our additional speakers for this program. Aaron Simpson is with me in the room with me. He has more than 15 years of experience advising clients on a broad range of complex privacy, data protection, and cybersecurity matters. He has worked in Europe over the course of the last couple of years and is truly an expert on the GDPR, and he'll talk to us about how the GDPR relates to the California Consumer Privacy Act in some interesting ways. Also joining us for the program is Brittany Bacon, who is a partner also with Hunton's Privacy and Cybersecurity Group. Brittany has received national recognition for her work in the areas of privacy and data security, and she is ranked in Chambers and was also named a New York Law Journal Rising Star, and as well as Law 360 Rising Star. So with that, let's just dive right into California. Since the early 2000s, California has truly been a pioneer in passing privacy legislation, and as an example, we can point to the first breach notification law that came out of California, and then followed by CalOPA, and then Shine the Light. So those were in the early 2000s, and then there was a bit of a lag between then and now. And of course now California has the distinct honor of having passed an absolutely sweeping privacy law that will impose significant new obligations on most businesses of any size in the United States. This law, I think it's fair to say, took the regulated community by surprise. It was passed in great haste, and its speed of passage is reflected in the fact that there were significant internal inconsistencies, there were downright errors, there were references to the ballot initiative which preceded the law, and I'll talk a little bit about that in just a minute. So it's a bit of a mess, but it's here to stay. It's our mess. So despite the inartful drafting in places, we need to manage this law and figure out how to deal with it. There has been already one set of amendments passed. This is likely to be the first of several sets of amendments, and we're going to address today's webinar on the basis of those amendments. They haven't been signed by the governor, but they have been passed, and we have every indication that they will. So we're going to speak as though they have already been implemented into law. I just want to note that this law is really quite inconsistent with our sectoral privacy regime in the U.S. and really serves more as a general privacy law, because it affects most industry sectors, and some have now been excluded, particularly by the amendments, but it really does affect most industry sectors. We'll take you through during this webinar the key provisions. We'll talk to you a little bit about a compliance strategy, and also consider how you can take advantage of all the hard work that everybody did to comply with the GDPR to get you into compliance with the new California law, which I'll refer to as the CCPA generally. Okay, just to give you a sense of our perspective and our privacy team, if you're not familiar, we have over 35 privacy and data security professionals in Asia, Europe, and the U.S. We cover the globe. And we represent clients in just about every industry sector, which we think is actually very important, because this compendium of law in this space is still really quite nascent, so we need to compare from industry sector to industry sector. Our practice is complemented by our Center for Information Policy Leadership, led by Boyana Bellamy, and CIPL is going to be doing some significant work in the United States. In California, yes, with respect to this law, but also at the federal level, as many of you have, I'm sure, been following, we are just seeing a process kick off by the Department of Commerce, by both NIST and NTIA, to put in place privacy principles and a framework in this country at the federal level. And of course there is federal legislation that's being discussed, and something will likely be introduced. So we're seeing just a huge amount of activity now. We just took a 2-minute breath after the GDPR, and our 2 minutes are over, and now we are focused squarely on the United States. So CIPL will be very active on the policy side, and of course the legal team here at Hunton will be very active on the legal side. Just to give you a quick roadmap of what we're going to talk about today, we're going to go over the background a little bit of this weird law, and talk about how to whom it applies, what information it applies to, as well as the rights that it confers on consumers. We'll talk about the training that's needed and how this will be enforced, and then give you some thoughts about a compliance strategy and how you can leverage your GDPR programs. So going to the background, this law has a bit of a muddled history. In November of 2017, there was a process kicked off, really formally kicked off, where a group called Californians for Consumer Privacy submitted an act as a ballot initiative for the November 18 ballot. This initiative was funded by a real estate mogul in California who decided a few years ago that privacy rights in the U.S. were inadequate, and that more protections were needed. So he expended millions of his own dollars in pushing this effort through with enormous success. In May of 2018, this is when we all really sort of sat up and took notice. We had been following it, of course. All of us had been following it. Everybody on this call, I'm sure, had been following it. But this is when we really understood that there was something significant happening here. There were then sufficient numbers of signatures to get this onto the ballot. And then by mid-May, there was an agreement with the legislature to withdraw the ballot initiative if a law could be passed that essentially embedded the substantive requirements of the ballot initiative. On June 21st, a law was introduced, and it passed 7 days later. Really an extraordinary effort here that is reflected in the sloppiness of the drafting. Who passes a law in 7 days? There were technical amendments that were made in Senate Bill 1121. Those passed last Friday. There were a few small substantive, very significant substantive changes for those whom those changes affect. We do expect there to be some additional amendments, but we're not counting on additional really substantive changes. We are counting on the Attorney General, who is required to issue 5 sets of regulations. So those will be coming down the pike, and I expect those to be more thoughtful than the requirements of the law. And the compliance deadline is a little bit in flux. It is essentially January 1st, 2020, but it can be pushed back 6 months if there is delay in issuing the regulation. So it is more likely to be July 1, 2020. So to whom does this law apply? It applies to any for-profit company that collects consumer information, does business in California, determines the purposes and means of processing the PI. Boy, does that sound familiar. So lifted directly from European law, as are some other phrases. We see in this law the term rights and freedoms. Never in any U.S. law have we seen that, in any U.S. privacy law have we seen that phrase used. It's lifted directly from European law. And a business needs to meet one or more of the following thresholds: annual gross revenues of over $25 million. That catches just a ton of folks right there. or maintains the information of 50,000 or more consumers, households or devices, and I just want to focus there on the word households. This is the first time we're seeing a law keyed in on household data, so very important, or where a company derives 50% or more of its revenues from selling consumer personal information. The definition of consumer is extraordinarily broad. It is a natural person who is a California resident. This could be read to cover employees, service provider representatives, business partner representatives, guests to your facility who sign your logbook in the lobby in California, really just about anybody who resides in California. So it's extraordinarily broad. We'll see. This is a natural place, as far as I'm concerned, for some narrowing, but we'll see what happens there. But certainly, consumer is not defined in the more typical way that we think about the term consumer. There are some exemptions. So for de-identified and aggregate data are excluded. HIPAA-covered entities, and this is new in the amendments, HIPAA-covered entities are excluded. PHI had been excluded previously, but now we see HIPAA-covered entities excluded in its entirety, as well as PHI held by business associates. So HIPAA is out. And then we got some relief also for financial institutions and consumer reporting agencies, as well as DPPA data. So in the amendments, that data, FCRA, GLB, and DPPA data is now excluded. That does not, however, mean that employee data, for example, of these entities is excluded, and that's distinct from HIPAA-covered entities where the entities themselves are excluded. So very important to keep an eye on this. This is, as far as I'm concerned, a natural place for some amendments and clarification. Turning to covered information. So this law applies to personal information, which is extraordinarily broadly defined, arguably broader than the GDPR in Europe. It is data that is capable, that relates to or is capable of being associated with or reasonably linked directly or indirectly with a consumer or household. There's that word household again. It excludes actually a very narrow set of publicly available information. This is another place where I think there is a natural amendment, room for an amendment here, because it's just too narrow in its definition of publicly available information that's excluded. There is a list of examples of personal information. We have some of the usual things like name and address, IP address, that's pretty usual these days, social security number, of course, but then we have some more unusual itemized items here, like olfactory information. That's my personal favorite. Olfactory information, to the extent it can be indirectly linked to a consumer or household or is capable of being associated with a human, can fall within the definition of personal information here. And then there's also a line item for employment-related information, which is interesting. Query whether that points to the actual intent of the drafters to include employee data. I don't know the answer to that. And then importantly, inferences are also included as among the enumerated examples. So the quick takeaway here is this is a very, very broad definition, and we need to be aware of that because every piece of this law is affected by the breadth of this definition. I'd like to turn to Brittany, who will describe the rights that the law grants to consumers. Over to you, Brittany.
Great. Thank you, Lisa. So as Lisa mentioned, the CCPA grants a number of rights to consumers which is very broadly defined. And these rights are broader than those currently contemplated under U.S., state, and federal general privacy laws, so it is quite significant. I'm going to touch on each of these and dive into them a bit deeper in later slides. But at a high level, the rights we're focusing on have to do with access or to receive information about the types of PI that a business collects or sells or discloses about a consumer, deletion of personal information, and then a right to opt out of the sale of personal information in certain circumstances. Taking first access. So under the CCPA, a consumer has a right to request that a business that collects personal information about that consumer disclose to the consumer certain information. This information includes the categories of personal information that the business has collected about that consumer, the categories of sources from which the personal information is collected, the business or commercial purpose for collecting or selling the PI, the categories of third parties with whom the business shares personal information, and finally, the specific pieces of personal information that the business has collected about the consumer. Now, as drafted, we don't have great clarity on what is meant by specific pieces of personal information. Does it mean that the business has to turn over all PI, a copy of all PI that was provided to the business? We think it may be that it may suffice for a business to disclose which of the general categories of personal information that it collects did the business actually collect for this particular type of customer. But there hopefully will be some light shed on that particular point to help facilitate compliance. With respect to data that personal information that a business sells or discloses to a third party for a business purpose, and I'll get into what each of those terms mean. A consumer also has a right to request, in addition to the information I just discussed, the consumer also has a right to request that the business disclose to that consumer the categories of PI that the business sold about the consumer and the categories of third parties to whom the personal information was sold by category or categories of personal information for each third party to whom that personal information was sold. And finally, the business is required to disclose the categories of personal information that the business disclosed about the consumer for a business purpose. So what do we mean by disclosure and what do we mean by business purpose? The CCPA does not actually define disclose or disclosure. It does, however, define business purpose, and it defines it as follows. The use of personal information for the businesses or a service provider's operational purposes or other notified purposes, provided that the use of personal information shall be reasonably necessary and proportionate to achieve the operational purpose for which the personal information was collected or processed, or for another operational purpose that is compatible with the context in which the personal information was collected. That is a mouthful to say and to hear, I'm sure. The CCPA does provide actually a list of enumerated business purposes. There are 7 of them. As it's drafted, it appears that this list is actually a definitive list as opposed to a list of examples. Remains to be seen whether we'll get some additional guidance on whether it's a definitive list or a set of examples. The business purposes include auditing related to a current interaction with the consumer, detecting security incidents, debugging to identify and repair errors, performing services on behalf of the business or service provider, and so on. The other 2 rights that we'll dive into a bit deeper are the right to request that a business delete any PI about the consumer which the business has collected from the consumer, and there are exemptions to this requirement. Same for opt-out of the sale of PI. A consumer may direct a business that sells PI about that consumer to third parties to not sell such data to third parties, and we refer to this as the right to opt out. If you could turn to the next slide. So the first step in responding to a California consumer's request is to verify that the consumer is in fact a consumer in California. The CCPA defines verifiable request as a request that is made by a California consumer for herself or for her minor child, or a natural person or a person that is registered with the California Secretary of State and authorized by the consumer to act on the consumer's behalf. We imagine this may result actually in some of it, bit of an industry for third parties that are going to fill this role and act on consumers' behalf to submit such requests. A request is verifiable if the business can reasonably verify that the person to be the consumer about whom the business has collected PI is in fact that consumer. The CCPA does not provide at this point specific guidance on how to verify a consumer's request. It does note that the AG will be developing regulations which hopefully will shed more light on the verifiable request process. One example given is treating a request that's submitted through a password protected account with the business as a verifiable request if it's sent through that form. How to verify when it comes to access and deletion requests to identify the consumer. The key is to associate information that's provided by the consumer with any personal information that was previously collected about the consumer. There is a timeline, so 45 days is the deadline for responding to a verifiable request. There are extensions possible, which I'll discuss in a moment. Moving on to the next slide. So doing a deeper dive into responding to access requests. As I said, first step, make sure it's a verifiable request. Once the business has done so, the business must disclose certain types of information depending on the circumstances, whether the personal information was simply collected by the business or whether the business also sold such PI or disclosed the PI for a business purpose. The business's disclosure, importantly, must cover the 12-month period preceding the business's receipt of the verifiable request. So you only have to go back 12 months. The disclosure must be made in writing and delivered through the consumer's account with the business if the consumer maintains an account with the business, or by mail or electronically at the consumer's option if the consumer does not maintain an account with the business. And it must be delivered in a readily usable format that allows the consumer to transmit this information from one entity to another entity without hindrance, which sort of resonates with the data portability concept that Erin will touch on later in the EU. As I mentioned, the business must provide 2 or more methods for consumers to submit requests, one of which has to include a toll-free number and a website if one is maintained by the business. In terms of timing, so a business must disclose and deliver the required information to a consumer free of charge within 45 days of receiving the verifiable request from that consumer. The CCPA does state that the time period may be extended once by an additional 45 days when reasonably necessary, provided that the consumer is provided with notice of the extension within that first 45-day period. So it is important to respond regardless within 45 days, even if it's just to say, we will be responding at a later time. There's a bit of discrepancy or lack of clarity in another section which notes that a time period for a business to respond to a verified consumer request may be extended by up to 90 additional days where necessary, taking into account the complexity and the number of the requests. If a business does not take action on the request, the business must inform that consumer within the period of time permitted of the reasons for not taking action and for any rights that the consumer may have to appeal the decision to the business. Okay, moving on to the next slide. With respect to deletion requests, so upon receiving a verifiable deletion request, a business must, 1, delete the specified personal information about the consumer, which the business has collected from that consumer, and 2, it must direct service providers to also delete the consumer's personal information. There are a number of enumerated exemptions under the CCPA whereby deletion would not be required, and I'll give you some examples. A business or a service provider is not required to comply with the consumer's deletion request if it is necessary to maintain the consumer's personal information to do one of a number of things. Some examples include if it's necessary to complete the transaction for which the personal information was collected, provide a good or service requested by the consumer within the context of an ongoing business relationship, or otherwise perform a contract with that consumer, detect security incidents, protecting against malicious, deceptive, or illegal activity, debugging to identify and repair errors, exercising free speech, ensuring the right of another consumer to exercise his or her right of free speech. Exemption is also provided for compliance with the California Electronic Communications Privacy Act. Other exemptions include compliance with the business's legal obligation, also to enable solely internal uses that are reasonably aligned with the consumer's expectations based on the consumer's relationship with the business. In that case, again, deletion would not be required if it's necessary for those internal uses. And then there is a catch-all whereby deletion is not required if it is necessary to maintain the consumer's personal information to otherwise use the consumer's PI internally in a lawful manner that is compatible with the context in which the consumer provided that information. Moving on to the next slide. So with respect to the sale of PI, there is a right that we refer to as the opt-out right. When we talk about sale, the definition under the CCPA is selling, renting, releasing, disclosing, disseminating, making available, transferring, or otherwise communicating orally, in writing, or by electronic or other means, consumer's PI to another business or third party for monetary or other valuable consideration. Now that last piece, or other valuable consideration, is an important point because it seems to go beyond our traditional understanding of what a sale means, where literally a business sends a set of data over to a third party. The third party then compensates that business for the data. Valuable consideration may be in another form that's not monetary. So this definition of sale is quite expansive. There are a number of enumerated exemptions that exist under the definition of the sale of PI. With respect to the sale of PI, the business must provide a clear and conspicuous link on the home page that says, "Do not sell my personal information." And the business, if the consumer opts out, then the business is prohibited from selling the consumer's personal information, and is also prohibited from asking that consumer again to authorize the business to sell their data for the next 12 months. So you can't go right back over to them and say, "Are you sure? Would you like to reauthorize us to do so?" Opt-outs may be provided by an authorized third party, so a consumer may authorize a third party to opt out on the consumer's behalf. With respect to minors, if the business has actual knowledge that a consumer is under 16, then the business is prohibited from selling the consumer's PI unless the consumer or the consumer's parent, for consumers under 13, affirmatively authorizes the sale. Moving on to the next slide. There are also they're referred to loosely as rights under the CCPA, non-discrimination and financial incentives. Under the CCPA, businesses cannot discriminate against a consumer for exercising their rights under the CCPA. You cannot penalize them. But you can charge different prices if the price difference is reasonably related to the value provided to the consumer by the consumer's data. It's a bit unclear here where to draw the line. You can imagine that can get quite murky. And finally, the business can offer financial incentives for the collection, sale, or deletion of a consumer's PI. Moving on to the next slide. Service providers and other non-third parties. So this is, talk about a mind meld. This is where the CCPA can get quite convoluted, and it's a bit unclear why certain provisions focus on the concept of a service provider and others focus on, in the definition of third party, entities that are excluded from that definition, non-third parties, which actually have very similar descriptions as service providers, but they are distinct. So under the CCPA, a service provider is defined as an entity that processes information on behalf of a business. It's also an entity to which the business discloses a consumer's PI for a business purpose and pursuant to a written contract that prohibits the service provider from retaining, using, or disclosing the PI except to perform the services specified in the contract. There are some benefits to being deemed a service provider under the Act, and that is, in certain circumstances, a consumer may not opt out of the sale of their PI if the sale is to a service provider. Separately, businesses do not have to disclose the service provider as a category of a third party to whom the personal information is sold. Now, where we get into when a service provider would also constitute a non-third party or an entity that is excluded from the definition of third party, if the service provider contract also includes a written certification and certain additional provisions that are enumerated in the Act, the service provider would be deemed a non-third party. This is important because non-third parties are exempt from the business's opt-out and certain opt-out and disclosure requirements. As I mentioned, the CCPA also requires service providers to delete consumers' PI from their records if the business that collects the PI directs them to do so. So while there are some benefits to being service providers, there's also a requirement that if an entity constitutes a service provider, they must delete the PI from their records if the business that collects the PI directs them to do so, again, pursuant to a verifiable consumer request. The CCPA does address specific liability shifting in the vendor or service provider non-third party context. When it comes to service providers, a business that discloses personal information to a service provider or a non-third party is not liable under the CCPA if the service provider that received the personal information uses it in violation of the CCPA, provided that at the time of disclosing the personal information, the business does not have actual knowledge or reason to believe that the service provider intends to commit such a violation. And again, a service provider, on the other hand, is not liable under the CCPA for the obligations of a business for which it provides services as set forth under the CCPA. I'm now going to turn it over to Lisa, who's going to talk about notice requirements.
Okay, terrific. Thank you very much. And the notice requirements, I think, are going to be among the most significant for the most companies, because every company is going to need to think about their privacy notice every 12 months. There is a requirement to update the notice annually. So this is going to be a bit of a bugaboo, I think, for many companies in the United States. You need to describe some of the usual types of items that we are now sort of routinely describing in our privacy notice, but there is really quite specific and prescriptive language. You need to describe the rights of access, deletion, the right to opt out of the sale of PI, as well as the anti-discrimination clauses, which are, as Brittany conveyed, quite muddled. You need to provide a method for submitting those requests, and it needs to be 2 of them. Talk about the categories of personal information collected in the preceding 12 months, as well as the sources from which you obtained the information and the purpose of collecting and uses of information, as well as the third parties. And this is a weird one, the specific pieces of personal information collected, which is really, it's interesting to me in its specificity. Also, the lack of sophistication really in calling it specific pieces rather than data elements as we're used to in global data protection laws. If the business sells personal information, you have to have 2 separate lists, the categories of personal information sold, and then separately You also need to list the categories of personal information disclosed. Next slide, please. And here we have a number for those of you who are looking for CLE credit. Please complete the attorney verification form with the code HAK, H as in Hunton, A Andrews, K Kurth, 63615. One more time. Exclamation point. One more time. HAK 63615, exclamation point. And if you didn't get it, please just email us and we'll be happy to convey it. Okay, let's move on to the next slide, please. And one more. All right, let's go moving on to training. There are required training elements in the law. We're required to ensure that anybody responsible for handling consumer requests or responsible for compliance with the law be trained with respect to access request, sale opt-out, the anti-discrimination clauses, as well as the related financial incentive clauses. So, along with that annual update of your privacy notice, we have to think now about ongoing training as well for existing and new hires. Enforcement. Let's talk about enforcement. So this is an area that really has changed quite significantly in the amendments. And we got a question, by the way, about whether this deck reflects the amendments. It does reflect the amendments. So we are assuming that the governor is going to sign them. So I just wanted to make that clear. So the law is enforceable by the California Attorney General, and the AG can seek injunctive relief as well as civil penalties that can reach up to $7,500 for intentional violations. Businesses have time to cure, which we've seen in other California privacy laws. So this is a very useful provision. You have 30 days to cure. And we'll talk in a little bit about your compliance program, but the very important piece here to just hammer home is you need to make sure that you're being notified of any notice of a violation, because if you don't get notified timely and the notification, the communication comes in through somebody who doesn't escalate the issue in a timely manner, you will lose that 30-day cure period. Enforcement, as I said earlier, generally we're sort of looking at a July 1, 2020 date. It could be as early as January 1, 2020, so we can't linger in thinking about moving forward with respect to compliance, but it will likely be July 1, 2020. There is also a private right of action, but this has been severely limited, which we're all very pleased about in the amendments, limited to only breaches of consumer personal information. There is an ability to recover statutory damages of up to $750 per consumer per incident, or actual damages if those are higher. Again, here there needs to be 30 days written notice and an opportunity to cure. I don't know exactly what that means in a breach situation. I don't know how one cures that, but there we are. With respect to actions for actual damages, there is no 30-day notice period there. Next slide, please. All right, let's move on to a compliance strategy. We are taking to heart the lessons that we've learned from our experience with the GDPR. We had 2 years to get into compliance with the GDPR. This is not nearly as complex as the GDPR. It just isn't. It's been compared to the GDPR, and we think there are a number of places where there are similarities, and certainly places where you can leverage your GDPR program, but it's not even close to as complicated. However, it will take time to get into compliance, and this is the time to get started. It's never too early, so that we can think about this at a more leisurely, not breakneck pace as we had for in some pieces, at least in some of our clients, for GDPR. So in thinking about a strategy, and we'll run through each of these items, we have to think about whether we will apply the CCPA only to California residents, or are we going to apply the rights granted, for example, more broadly to all U.S. residents, since Europeans have those rights as well. And then we need to think about having data inventories, notice. We'll think about how to deal with consumer rights and opt-out mechanisms, as well as vendor contracts. So let's move on to the next slide, please. And I just want to note that this law we are told, is being considered by other state legislatures. So it may well become a blueprint for other states to replicate, and certainly it's going to be difficult for companies to comply with this California law and not apply some of it to their overall population, because the reality of life is that data is maintained in databases in a way that does not allow distinctions so easily for California residents. So starting with data inventory and mapping, we need to know where our data is. We need to know what data we have, where we got it, and with whom we're sharing it. We need a lot of information now, just as we did to comply with the GDPR, about our data in order to comply timely with the requests that we may get from consumers. So it is important that you have good, strong data inventories so that you understand the data cradle to grave. You understand what you're collecting, from whom you're collecting it, how it's used, and with whom you're sharing it. We also need to understand what practices are exempt. Do you have de-identified data? Do you have aggregate data? Is there PHI in the mix? Is there data that is subject to the GLBA in the mix, so that data is excluded? And then, very important, to make sure that your data inventories that you're preparing in connection with CCPA compliance is actually all reflected in your privacy notice. There needs to be consistency there. And I'll also just note here that we have seen a tremendous uptick in the number of Shine the Light requests. So from, I think it was 2004 that Shine the Light passed, or the early 2000s, till about 6 months ago, we had gotten, a dozen, maybe 2 dozen Shine the Light requests in all that time. And then since, for about the last 3 months, we have seen a huge uptick, and we've seen more Shine the Light requests from our clients in that period than we saw in the entire decade plus of Shine the Light requests before that. So plaintiffs' counsel are getting very, very active here. They know this is an area that's ripe for picking. Next slide, please. With respect to notices, as I said, we're going to need to think about revising privacy notices now annually. The most interesting part of this for me right at this moment in time, and this may change, is that there is at least a suggestion that we're going to need to make privacy assertions and have privacy notices with respect to HR data, if this law is deemed to apply or doesn't exclude employee data. Will we need privacy statements for our service providers? So these are all questions I think that we will need to grapple with over the next months, year or so, and hopefully there'll be some clarification on these questions. But it may be that for the first time in the United States, there may be a mandate to have an employee privacy notice in place, because we need to convey some of these rights to those who can take advantage of those rights, and those are consumers, as defined in this law very broadly. And we also need a process then in place to annually review any such notices, so that we're updating those notices every 12 months. Next slide, please. We will certainly also need procedures in place to allow for the rights to be exercised. So we need to verify consumers' identities, and there's as Brittany described, a pretty detailed verification process in place that needs to be in place. We need to be able to respond quickly to access and deletion requests and process opt-out requests, and also direct service providers in flow-down requirements to do the same. And we want to make sure that we're tracking and logging any requests that come in, as well as the disposition of those requests, and training the appropriate individuals who are going to be dealing with all of this. And once we have a process in place, we certainly want to test it before the law comes into the compliance deadline comes to pass. We want to test whether our processes are actually doing the trick. Next slide, please. With respect to opt-out mechanisms, there is a requirement to have a toll-free telephone number and web page to opt out of the sale of PI, and certainly we're going to want to keep logs and have good records of any consumer opt-out requests. And then, again, I pose the question of, do we want to apply this right more broadly than just to California residents? And that's a question for every company to answer for itself. With respect to vendor contracts, there also needs to be a process, and if we haven't had it with GDPR, here we go again. There needs to be a process to review and amend vendor contracts to include the provisions that now must be covered pursuant to the CCPA in vendor contracts, as well as obligations that flow down to vendors. And we need to get this certification, this new concept of a certification, which certainly we can think about just putting into the MSA with a vendor to just say, a vendor certifies that, and just have that as part of the contract as well. Next slide. Managing the liability risk. So we want to make sure that we're keeping good records of any notices that come in from the AG, as well as consumers, of violations of the law. And as indicated earlier, there's a 30-day grace period, so we really need to keep track of what's coming in the door, and make sure that we have a sufficiently strong escalation process so that whatever comes in bubbles up to the right place as they're coming in the door. With that, I'd like to turn to Aaron to talk about how you might leverage some of your GDPR compliance program.
Thanks a lot, Lisa, and thanks, Brittany, and thanks to everyone who's joined today. As you've all just heard, the new law is different from the GDPR, but this California law is a bit of a bear. And for many of you, this sort of news or this law is probably a difficult pill to swallow, given how grueling the effort was to address the GDPR's requirements ahead of the May 25th enactment date. But I think there's some good news here too, at least for some of you. Companies who are reasonably prepared for the GDPR, as Lisa has suggested, are in a solid position to get into compliance with the CCPA, as well as, let's not forget, other laws that are emerging across the world as we speak. Important GDPR program building blocks like understanding data flows, developing privacy notices, and responding to requests from data subjects are going to be highly leverageable in the CCPA context. Obviously, while this compliance framework that many of you have built will be leverageable, it's also going to be important to consider some of the substantive differences in the CCPA as you proceed with your compliance remediation. Moving on to the next slide. Diving into the rights requests specifically, the concept of consumers having rights to make certain requests is obviously something that all of you who've done European data protection law for many years, including more recently with the GDPR, are going to be familiar with. Many companies have developed procedures, some of which have been very sophisticated, to help them respond efficiently and effectively to GDPR requests. These procedures are going to be very, very helpful, obviously, for CCPA purposes. Things like authenticating the requester, escalating the requests, prompt response. These are the hallmarks of any compliance program, right? Yes, they were drafted in many ways to deal with specific rights under European law that may or may not exist under the CCPA, but the concept remains highly, highly relevant and highly leverageable. Once you get into the details, and the devil's always in the details, you're going to need to be sure that your procedures contemplate the CCPA's unique requirements. Brittany mentioned the 45-day response time versus the 30-day response time. That's something that obviously can be leveraged to your advantage if you want to, or you can also hold yourself to a higher standard. There are some other things that you're going to need to do as a process matter, like maintain records under the CCPA and the GDPR with respect to the requests you've received and how you've responded. And it's going to be important, as Lisa mentioned, sometimes it's very difficult as a practical matter to sort of tease out how you process personal data about Europeans versus Californians. Not every company's systems are set up in a manner that allows that to be done very easily, but it will be important that you understand how to keep your records separate and make clear which regime was relevant, because companies that bungle rights requests in Europe and probably soon to be under California are companies that have to deal with regulators, right? This is often how these types of issues can arise. Many of the regulators around the world are complaint-driven. Many have statutory obligations to pursue complaints with companies who have been complained about, and so this is how things arise. And so efficient and effective management of rights requests under both the GDPR and the CCPA, we think, is a really important compliance tool, but also risk mitigant in a practical sense. From a training perspective, obviously you could have the best rights request response procedure the world has ever seen, and it's next to useless if you've not trained the staff who will be charged with doing the work on how to read those procedures and how to understand them. So there are some obvious opportunities here to leverage your training that you're going to be doing under the GDPR, perhaps you've already done under the GDPR, and extend it to those of your staff who are going to be helping with the California compliance. It's going to depend. We see as outside counsel a lot of different information governance models for our clients, in many cases depending on how big they are or how geographically spread out they are. If your business is likely to receive a considerable number of requests, and some of our clients fall into that category, it may be worth having different teams or at least different processes to ensure that the requests are appropriately channeled and the relevant employee is aware of the appropriate deadline and specific details they need to be aware of. In other cases, that may not be a business model that is necessary or that will even work properly within your organization. So you'll need to think about how exactly you're going to leverage your GDPR approach if you've developed one to access requests or rights requests. But there's certainly a lot to be gained from the GDPR homework that has been done to date on this very, very important topic. Moving on to the next slide, privacy notices, transparency. Those of you in the U.S. have been familiar with the importance of privacy notices for a very, very long time. This is because under U.S. federal and state consumer protection jurisprudence, a company's privacy notice contains actionable representations. You all know this. In Europe, privacy notices have always played a very different role. And this primarily stems from the fact that data protection issues have always been regulated substantively in Europe. And so what that means is your practices in Europe were going to be subject to these substantive requirements no matter what you say in your privacy notice, right? Whereas in the U.S., perhaps underlying substantive requirements have been lacking, and so what you say in your privacy notice in some ways has always become the rules of the road for the organization, right? This is a really important difference, and this difference has been reduced, if you will, or changed a bit with the GDPR, because under the GDPR, Article 13 requires companies to publish a privacy notice, and that privacy notice must include specified content. Until the GDPR, I think it would be fair to say that far more attention has been paid to privacy notices in the U.S. than in Europe. But that has changed with the GDPR, and it's going to change further with the CCPA. There are a number of content requirements under both the CCPA and the GDPR that do overlap. So some of the work that you've done to get your privacy notices into GDPR compliance are going to be helpful. I've listed in the slides a number of examples of content requirements under both laws that need to be included in privacy notices, like the categories of data that you collect, the categories of the sources from which the data is collected, the rights of individuals, a description of those rights, the purposes for which you process personal data, and the categories of third parties with whom personal data is shared. These are all leverageable concepts, and so again, silver lining here with your GDPR advanced work, this is going to be helpful. But like I said, for most U.S. companies, you've done a pretty sophisticated job with your privacy notices for a long time, so I actually don't think that this should be too burdensome for all of you who have thought hard about what information you collect, how you use it, etc. There are some scope considerations in terms of where your privacy notices apply. Is it website only? Is it online? Is it offline? And those will be difficult to deal with. But the principle remains that I think a lot of the work you've done, both to comply with U.S. law historically and now to comply with the GDPR, will be very, very helpful. Next slide, please. Data inventory and mapping. I think this is probably the most important area of convergence for all of you who spent time working to comply with the GDPR. I think that it goes without saying that a sophisticated understanding of your data flows is the foundation of any privacy or data protection compliance program, right? And there's many degrees or levels of articulation with respect to understanding your data flows. There are companies and clients who've spent tens of millions of dollars with lots of different vendors to understand their data flows, and there are others who have sought to understand those data flows at a higher level of articulation. No matter what level of articulation you understand, at which you understand your data flows, GDPR compliance and CCPA compliance depends on that understanding, right? You can't really comply with privacy laws if you don't understand the data you collect, how you use it, who you share it with, how you secure it, how long you retain it, etc. Right? These are important aspects of your business, and compliance with these laws and other laws that are emerging around the world depends on this understanding. So the GDPR, while not requiring you to do some sort of data flow analysis, getting into compliance did provide many companies with an opportunity to better understand these data flows. And this understanding was oftentimes not compartmentalized to Europe because of the nature of systems and how they interact with one another, because of the extraterritorial aspects of the GDPR. A lot of companies have a much better understanding of their global data flows as a result of the GDPR, and this understanding will need to be leveraged to assist with CCPA compliance. This is a monumental task, right, for companies who haven't done it. But for those of you who have done it under the GDPR, it may involve extending the scope. It may involve looking at it from a slightly different angle, but certainly the vast majority of what you did for the GDPR will be very, very helpful. In particular, to making sure your privacy notices are accurate, in providing you with an opportunity to more efficiently respond to rights requests because you understand where the data is that is subject to those types of requests, and you have systems in place to help you quickly deal with those types of requests and respond to them. Next slide. Revising and negotiating vendor contracts. So GDPR compliance required our clients to rethink their contracting strategy in many cases with third-party business partners, both with processors who they needed to enter into contracts with to comply with the GDPR in Article 28, but also with controllers, right? Because companies want to have contracts with their business partners to understand the rights and responsibilities of the parties in the context of the personal data processing, whether they're controllers or processors. So, some of the concepts required by Article 28 for processor agreements can be leveraged for use with the CCPA. Obviously changing contracts to reflect laws is not difficult. That's not the hard part. That can be done in a matter of hours. The hard part is executing, right? And for many of our clients that have thousands or tens of thousands of vendors, executing on these types of regulatory changes is a Herculean task. Business partners, I think, will be familiar with the concepts of the CCPA based on their GDPR experience, and I think that should have the effect of easing the compliance burden. And I also think that whatever negotiation strategies you all came up with at scale, if those strategies were necessary for your company, for GDPR will be very useful in easing the burden under the CCPA. And what I mean by that, is that a lot of our clients, developed very sophisticated approaches to their contract processes under the GDPR, whether that involved, creating templates and hiring third parties to help them, effectuate the contracts and negotiate the agreements. There were a multitude of approaches that companies have taken. And like I said, it was a significant aspect of GDPR compliance. So in those types of situations, I think leveraging the approach and some of the relationships that have been built with your business partners and contacts with those business partners will be really, really helpful. It obviously is still painful, and for some companies it will be particularly painful. But I think that the silver lining here is that a lot of the work you did in this area to develop approaches to execution at scale will be very useful. With that, I will turn it back over to Lisa.
Okay, thank you very much, Aaron and Brittany. We are bumping up against time. We've been watching your questions as they've come in. We've tried to answer some of them as we've gone, but we unfortunately have not been able to answer all of them. So certainly give us a shout if we can help answer some additional questions. Thank you so much for joining our program. We would invite you to visit our privacy blog at www.huntonprivacyblog.com. We will be posting on further developments with respect to the CCPA as well as other privacy and cybersecurity law issues globally, and we look forward to having you at future events. Thanks so much for joining. Bye-bye.